we wanted Tim Johnson to come to speak to us because we've been wanting a lawyer to speak to us about intellectual property, and he happens to be an intellectual property lawyer on Hilton Head. So he's local to us from Longship Legal, which he started with his partner.
Yep.
So he's the co-founder and CEO there, and he's has a storied career in law as well as the Navy, which he can talk to you about. So we wanted to have him specifically talk to us about intellectual property law, which is what we call copyright, as far as we care. Writers' contracts, as well as copyright for authors. And Jim Johnson, thank you.
Cool, thank you. Thank you very much for the applause, and thank you for having me. I really was great to find out that there was an Island Writers Network, and I very much appreciate the chance to come and talk to you all tonight. I am local. I live here in Hilton Head Plantation, just around the corner behind the high school and through the woods over there, and I've lived here for 10 years, so I'm not a full-time local in that sense of like, many years, and remember before Hilton Head Plantation was made or anything like that, but I've been here longer than a minute, and so I really appreciate the chance to come help you all hopefully a little bit, talk about a little bit about what I do, and maybe if we're lucky, give you a chance to take away from here a little bit better understanding of exactly how copyright might interact with what you all do, what contracts might be able to help you, or just open your eyes to when you bump into legal issues. So with that, I'm gonna get started. All right, so I was trying to figure out where does one start a discussion for a set of Hilton Head-based island, Hilton Head Island-based writers, and I thought no better place to start that than with two bookkeepers from Ohio, because half the island I feel is from Ohio, and so that's where I figured why not start there. And so the reason I bring up two bookkeepers from Ohio is because one of the things that always seems to come up with copyrights and intellectual property in general is the difference between when you have an idea and when you have something that's protectable. In this case from the late 1800s, it involved two bookkeepers in Ohio who had both written books on bookkeeping approaches, because remember this was before QuickBooks, before computers, and so how would you teach someone how to run their books or how to do their ledgers? You would write a book about it. And they had both written books, one from the greater Cincinnati area, Greene County, Ohio, and the other from Greene County, which is up more towards Dayton. And they ended up, after one of them passed away, not making a lot of money off the book that he had sold, and the other gentleman, Baker, had made a lot of money off the book he sold. The estate sued the estate of Selden, sued Baker, and it went all the way to the Supreme Court. And there in the late 1800s, the Supreme Court was asked to decide a slew of kind of things, everything from is a form copyrightable, right, because we've done these accounting ledgers, all the way to when does the idea of accounting become something that's protectable. And so it is still, while it's a relatively old case these days from the late 1800s, and we now have the 1976 Copyright Act, which codified a lot of the law that existed kind of in an American common law for copyright. It's still cited today and is the foundational underpinning of you basically what the Supreme Court tells us, you can't copyright an idea, but you can copyright the expression of that idea. And so in every time when we start to ask ourselves, do I have something that's protectable? What does this copyright system work? Can I copyright this? Hey, did that person take my idea? Is that my, all those kind of things you talk about in the regular kind of when people start thinking about what's mine, what have I created, where's my art, what have I come up with? We're always going to be asking ourselves, is that an idea, or is it something that you have taken the idea and turned it into tangible expression? And that applies across pretty much all types of intellectual property, and I'll run through the others just so, because don't worry, if you're out walking along the streets and you say intellectual property and you mean copyrights because that's what you're talking about, that's fine. If you say trademarks and you really mean copyrights, you say patents and you really mean copyrights, you say copyrights and you really mean patents, it'd be like, I don't know, 99% of all Americans, because only us crazy attorneys are the only people who actually are like, no, this is a patent and this is a trademark and this is a copyright. The rest of it's this big umbrella term, intellectual property, but it all comes down to once I've done something with an idea, something more of it, what type of legal protection is there for that, right? And so we'll explore it through copyright tonight, but we'll look at how it applies to all the intellectual property kind of regimes. And intellectual property is just a fancy way to say protections for ideas that your government allows, right? We could all come up with we could all agree, hey, if you come up with this idea on Tuesdays, it's yours. If someone else comes up on a Thursdays, we could make our own way of doing things. But intellectual property is just the regime that your in this case, the United States government has come up with to protect the expression of ideas, and the different types deal with the different ways of expression. And so with that, what we're going to cover tonight, I'll give you a quick background on me, although I've kind of hit all the exciting high points probably already. We'll talk about what writers are, which I think is germane to this group, to just kind of understand how you're coming at this big elephant that is intellectual property and what might apply to you all as you're writing and creating your works. Then I'll give you a broad brush stroke of intellectual property. The two things I want to focus on, because they're really where, if I look at kind of the mission of your organization, both helping you write and understand the business of writing, copyright is the legal regime that gives you the ability to have contracts for your works of authorship. And so we'll talk about those two. We'll hit on a few other issues which we definitely don't have time in 30 to 45 minutes tonight to get to, but it's things for all of you as writers to keep in mind. And then, the end, my contact information. And I'm happy to share these slides with anybody who would like them. So there's nothing proprietary here at all. So that's me. I'm Tim Johnson. I'm the co-founder of Longship Legal. We're a strategic legal advisory firm designed to really kind of change the way the legal services are delivered to folks. Looking at things from starting with why, looking at business as not just something that needs lawyers to de-risk it, but that can leverage law and intellectual property specifically to help businesses grow. And I'm a licensed attorney here in South Carolina. I'm also licensed in Virginia. I'm also licensed before the U.S. Patent and Trademark Office. And my firm, with Dave Himes, who's the other half of Longship Legal, he's licensed in Massachusetts as well. We both met working in Virginia. And so that said, I'm a former patent examiner. Before I went to work at the patent office, I was in the Navy. So I've done a few things, and I've been down here on Hilton Head for over 10 years now. Used to vacation, read a story in the Island Packet years ago while I was vacationing here that said, if you're reading this, you someday will live here. And I'm living proof that can't be. And so, so that's it. If anybody has any questions after this, my contact information is throughout it. I do have cards, glad to talk to anybody. I will admit, day-to-day author agreements is not my forte. I come from a technical side of intellectual property, much more through the patent side of things, and electronics, batteries, everything to design patents on buildings. I definitely know about copyrights. I definitely know about the law and contracts. There's a lot of things that don't change, but if you're like, hey, have you ever, had to sue Putnam? The answer is no, right? So my experience with copyright, the law is the same, but it comes through software, and copywriting code is mostly how I've interacted with the patent office, not through copywriting, authors' books. Although the procedures are slightly different, they still go to the same place. The law is the same, and the analysis is the same. So I can help you, but I will just tell you off the jump that I am not, you would be much better off finding a Manhattan attorney that had dealt with that. If you have really got a high stakes litigation, it's you versus Stephen King as to who came up with it first. I'm glad to help you find somebody to talk to, but it won't be me that's gonna walk in with you to court there, because I like to know what I'm good at and what I'm not good at. And so, I'm here to educate tonight. I'm not here to say, hey, you've got a representative for authors here sitting over in Hilton Head Plantation. Although always glad to help folks, and lawyers can be scary, so if you have a question, feel free to call me. All right, anything questions so far? Burning needs to know. Okay. Nope.
Are you covering what copyright is and what it covers?
Absolutely. So I'll get the way we'll break it down is what copyright is, how that flows, then we'll look at contracts, what they are, and what's I think you all should be on the lookout for as you're going into contracts. and then we'll touch on those kind of other issues, and I'm glad to answer any questions as they come
Could you
up.
throw in the concerns about AI that everybody has?
Sure, yeah, we can throw AI in at the other, that may take a whole other a session at the end, but glad to do that.
Can you give us an example of the difference between an expression of an idea and an idea?
Yeah, so an expression of an idea right now would be we sit around at the table and we discuss a potential character. We're like, what if we imagined a lawyer that was coming to talk to all of us, and we started discussing it, and that would be the expression of it. We would be sitting here, all of us would be talking about it, and that is just the idea of it. He'd got brown hair, he'd stand up and talk to us. It's all forming in our minds right now as we talk about it. We've expressed it. It has not become an expression of a work that is now tangible, that has been reduced to anything. So I'll skip forward and then we'll come back to writers, right? And so if you look at, and I just took, because it's best to go to the Copyright Office, but a literary work, described in areas of particular subject or theme, that's the text, right? And if you look at the broad, if you just start quickly grabbing the key points out of that paragraph describing what it is, and it might be small for the folks in back, you'll see that they have an intention to them, they're fixed in some type of media. And if you want to think about it, that difference between idea and expression of an idea and putting it into some media that is
So an
copyrightable.
idea is like characters, but the
Yep.
expression is a particular character.
No, it's the particular, even that particular character in the book, right? So you have to have actually written it down. So the, and copyright vests at the point that you put paper to pen, or you record it into a mic, or you do, anytime you take the act of the artist, you've expressed it now. But it's, that is the idea is the idea, and the physical description of it and the writing is when it becomes something that's copyrightable.
Okay.
And then there gets to be other points of it, which are derivative works. And so that character that's on your page, then potentially can exist in a movie and can exist in other places, right? So the expression, your one copyrightable way, or the work that you have, can then flow into other mediums and still have rights of you as the author who created that. But just by itself, the idea of a character, right? And that happens all the time. In Los Angeles, there's people who make their money, I think, both defending suits about potential, characters, and filing suits about potential characters because, hey, I sent you a manuscript and it said that there was this attorney who came in and talked, and your manuscript now has this attorney that came in and talked, and I pitched that story idea here, and that's mine, and so it really does come down
And who
to
wins that?
So that could get that in general, that just who's the character idea, it's almost not worth your time. My advice to you would be you can file any lawsuit you want in America, pay the court filing fees and walk into court, you can sue anyone for anything. The real question is, are you gonna win, right? And if we're in that fact pattern of you have an idea and I have an idea for two characters and we discussed them, even if we sat here and discussed them for hours, there's no rights in the expression to talking to each
No,
other.
I'm thinking what you were just saying. Say, we sent our manuscript to somebody
Yep.
and they read it, and then they end up publishing a book that has a very similar storyline in it.
Yep, so similar storyline, they're gonna win.
Who wins that?
Similar storyline, they're gonna win, unless you had some contractual relationship that said that they weren't supposed to do that. So we could dial it back, but in general, just, you were like, you know what, I really want, Universal Pictures to read my treatment of this book, my book I've written, I'm gonna send it to them. Barring a contractual relationship, even if it's just something of them saying, when you send us your manuscripts, we promise to read them and send them back without doing anything, whatever those, it could be something simple. But absent a contractual relationship, ideas are just ideas, even if you've written them down. Now if they actually stole it, right? They lifted the entire character, maybe they lifted the dialogue, starts to get a lot
Okay.
more
But
specific.
it would have to be that specific.
Yeah, it wouldn't have to be the whole thing, but it would have to start being that specific, right? If it turns, and there's some famous cases of pretty much any character trait, detective stories, right? Like how many detective stories hinge, the only difference being, does Detective A, are they in New York or are they in Los Angeles? Is the detective wearing trench coats or do they wear a leather jacket? And they can be very similar. The lawsuits will get filed, sometimes because it's cheaper to make people go away. They might get settled, but in general, the rule is the characters themselves, by themselves, don't have protection just for existing. Right? Now, there are some factors we get to because people are nefarious. There's a whole multi-factor test of did they have access to the manuscript, right? And so how much of it did they use, right? If they just used the title but they didn't use anything else because they liked your title, or titles by themselves copyrightable? Generally not, right? And so the facts get really messy really fast. My advice to you, and we'll get to that maybe in the contract section, is just don't blindly shotgun your work off to 1 million people without thinking through what are the consequences and what would I be unhappy about if, after I did that. And that'll set you up to just be a little bit happier, I think. It is tough advice to give, right, as an attorney, to say like, hey, I know it's tough, you gotta get a bunch of rejections, which means you gotta send your stuff out to have somebody like it and start publishing it, and a lot of things, especially in the old world before you could do self-publication. But just decide what you can live with, what you're expecting when you put it in that manila envelope and send it off, and what what you'll be happy or unhappy about. And that sets you up better than relying on sort of the de facto setting of the world, because the de facto setting of the world is not necessarily friendly to protecting things which are really hard to come by, of whose idea was whose first, and is that totally unique to you. It ended up being the most unique character in the world that no one, and you really were the first person to, come up with a detective, right? Maybe it'd be a different analysis, but that's the kind of how messy it can get. Any other questions before I jump back to kind of the linear flow? And maybe we'll answer more of these in detail here. All right, so writers. Copyright covers all kinds of things. We're going to focus tonight from the lens of writers, which is an author who uses the written word as a tangible medium for expression of their original work. So if we take kind of all the things we've looked at, a writer is somebody who doesn't have to be pen to page anymore, right? But they've taken something designed to be read by other human beings. That's a writer. Poems, novels, periodicals, magazines, news stories, anything that is designed to be read is where we start thinking, does authorship apply? Does that apply to writers? The reason it's worth keeping in your mind is even when you go to the copyright website, if you have a question about how would I file something if you wanted to do it yourself, you're pretty quickly going to get a bunch of different options depending on what you have created, right? So as the creator, if you've done music, there's a different filing process for music. If you've done, a book, there's a different process for book. The number of deposit copies you need is different depending on the type of work that you've created. And so tonight I just want to set up, tried to make this information, it's general, but it's also where there's a choice, I've guided it towards really only focusing on the writer side. So if you're coming up with, hey, that's great, what about this TikTok video? I'm not trying to give out TikTok video, advice tonight, although that is out there as well. It does start to get, I will admit, most of the modern stuff, the money these days is it's great to be Stephen King, right? But on average, media is consumed these days through movies and television and music. And so lawsuits follow the money, and most of the money is in those types of delivery mediums, not in print authorship. So it doesn't mean that the rules aren't established or that the things that happen in those cases can't apply to print authors, but it's not as most of the litigation going down these days is not focused on writers. Does that help? All right, so we've kind of already hit on this, a legal regime for intangible assets. A way to think of the thing is intangible assets. There's a lot of intangibles in the world that you can kind of generate revenue from. Your networking of people you could argue is an intangible asset. The legislation you might get if somebody's going to give you a special grant or a right to do things. But then when you get to intellectual property, what you're really looking at is like, okay, what has the government put a wrapper around that has set up a set of rules that allow us to transact those with each other? And so we've taken this broad general area of intangible assets, which accountants might carry every one of those in kind of their goodwill line in an accounting ledger. And we've gone to, let's take a subset of that and see what is things that the government has said, here's how we will allow you to transact them among each other, and here's how we'll protect the rights of them. And so the best known ones, those trademarks, trade secrets, patents, and copyrights. Tonight we'll talk about copyrights, but I just listed a bunch of examples, right? These are all subcategories of the intellectual property, right? Jacket designs, domain names, mask works, hull designs, geographic indications, books, music, database rights. The kind of list goes on. Tonight we're going to talk about really works of authorship. So any questions now before we jump into kind of copyrights in general? All right, so copyrights, they protect the creative works that give expression to ideas, right? And I know I apologize if I'm, kind of the vernacular I can use sometimes flows across different ways, right? So if you get confused, don't feel free to stop me, because a lot of the words come up in both their legal meaning of things and how they apply to the specific scenario you're having, and then kind of the general way we talk about things as human beings. And those two languages are not the same all the time. I tend to default to kind of the way some middle ground, right, of like where Tim's crazy brain is thinking about both the words and puts them out. And so sometimes I know I can be confusing because I'm using kind of regular vernacular and legal vernacular at the same time. So if you're ever confused, feel free to stop me. You will not hurt my feelings of saying like, hey, what is that guy talking about? So copyrights, way to think of it, they really weren't necessary until the invention of the printing press. Potentially existed before that, but up until then, the friction in creating a copy of somebody's work was so high that it really was only done, nobody was doing it at scale, and they weren't making a lot of money off it. After the after the invention of the printing press, you have quite a few years of tumult, Protestant Reformation, all kinds of things going on, and finally they decide, all right, maybe we need some rights around this. And so the kind of codification of that, we reach back to about the 17th century in England, and we as English colonies that fought a war to leave Britain, turns out after the war we were pretty much like, all right, how do we administer ourselves? We're like, I know, we'll do everything we did there except the king won't be in charge, right? So our laws literally reach back to, used to reach back to English common law on, and still do sometimes if we come to an intellectual property question that is not answered in our statutes or in our previous jurisprudence, you end up reaching back to black letter law as it was pre-revolution. And so the 76 Act, the 1976 Act for copyright kind of helped that of like, okay, let's stop reaching far back for this. And so now a lot of that's codified, put into the Copyright Act, but that's where it comes from. It's still English common law living with us today, even in the digital age. So it's a registration system that has some interesting things. It's not, how many people here have applied for copyright before? Okay, so I've got a few. So everyone, who here has ever put a pencil or a typewriter and written something on a page, a computer that was something they created? It wasn't just answering a question on a test. Everybody in the room, right? So everybody in the room has copyright. Everybody does. The second you do that, even if we're scribbling notes, if I said everybody write something down right now, we'd all have a copyright. It vested at the moment that we wrote something down. That means it came into being in a legal sense. What we don't all have, I think only 3 of us raised hands in here, is a registered copyright in those works. In America, you have no need to register your copyrights. They exist the moment you create the work of authorship. What you don't get from them until you've registered them is ability to do things with them, right? So you can actually contract with them. You can even there's some more modern laws like the Digital Millennium Copyright Act will let you give people takedown notice or stuff. But in general, what do you get from registration? You get the ability to go sue people, and you get the ability to try to stop folks from taking your works, and you help yourself in monetizing your works if you're going to sell them and transact them. But you don't need to do registration, right? So in that sense, nobody feel like you're running out of here and you have to go register all your copyrights tonight. It is not an emergency. They exist at the point where you create them. It's a little different if you're ever thinking about patents, right? Patents have a requirement for examination. It's not a registration system, so you can have an invention, you can come up with something new, but until you have gone to the patent office and until you have gotten the patent office to stamp it, you don't have a patent in that cell phone technology. And so it's a little bit of a different approach. And so sometimes if you're talking about generally intellectual property, you can end up, some people get confused like, oh, you have to do this, and for certain receipts. Same goes for trademarks. You have a trademark when you sell something. The instant you sell something with any unique branding on it, it doesn't have to be registered. It does need to be registered for you to get most of the teeth for going to sue somebody. And so the difference between a registration system and an examination system, patents, the government has to stamp that and say, yep, that really was new. Now you're entitled to it. You get it after they've been involved in the process. Copyrights, trademarks, they exist without registration. Registration just gives you benefits to the that you get for registering them. So does that make sense to everybody? Because it is a little thing. And so Copyright Office is right here.
Sorry, you lost me on one thing.
Yeah.
So if we're writers, we're writing articles or creating our own, I mean, obviously there's nothing new under the sun in a technical sense, but if you're writing about things you've heard about, or it's your own wisdom, or you contribute, or say, here are the sources I chose, or not, as the case may be. All of is that copyright or not quite?
So it depends on what you're doing. If you're, you know, if we use a journal article or something as an example, right? And so you have written that, and there's 32 sources behind it that you've cited for all the paragraphs that are in it.
Or I didn't publicly cite it, but that was my research.
It doesn't matter kind of in that sense, right? It depends on what the level of extraction is, and so that's going to come up two ways, right? In the people that might be accusing you of taking something, it's a question of, is it fair use that you've used, you know, excerpts and things. But for the actual author, if we go back to the accountants, what was protectable in there? It was, the books were copyrightable, right? And to the extent that there was something in them that was talking about how to do accounting, it was unique expression. They were not copyrightable for the general idea of accounting by itself, right? And so because the two books were not direct copies of each other, that's why he didn't end up winning his lawsuit, or his estate didn't end up winning his lawsuit. And so in that, when you've written an article, even if you're citing other things and you're putting it there, it still becomes your unique collection of things. And so one way to think about kind of the example given in law schools, and this comes from another thing, is none of the phone numbers in the phone book are copyrightable. None of them. The phone book as its whole self is copyrightable. And what's in there? It's bare minimum of expression, right? But somebody had to choose, hey, do we do this in phone number order, or do we do it in alphabetical order? Somebody had to choose, how do we do the headings? Do we, put them up at the top and things? And so if I copy your phone book, full cloth or most of it, I probably have committed copyright infringement against the limited copyright you have in the. If I just make a phone book, even if I copy all your numbers, and that's what happened in the case, I've not committed copyright, infringement, because I've taken the numbers that are just generally known facts and put them. It's why two people can write about the same military battle without, two books on Gettysburg don't create copyright infringement among the two books on Gettysburg. Does that help illuminate it?
Sort of, yeah.
Well, it's
like Billy Collins' poem that she read. So if I just took an excerpt and then integrated it into, without giving him credit, in my article of whatever I was writing about, maybe some wisdom about education, that would be infringement?
Yeah, potentially. If you took it, well, even with the attribution, right? If you're using it for monetary purposes, right? Like think of it, if you made a compilation of your favorite poems, put them all together, slap the front on it, slap the cover on the front and the back, and started selling it for $5 out here in Island Rec. Right. More power to you. I hope people would take that up and buy it. But yes, each time you did that would be copyright infringement of their right to be because it's not just, the copyright isn't just the right to write, it's also the right to control how it's published, it's the right to control the distribution of it, it's the right to make money off the distribution of it. And so, yeah, if you did that. Now, if you took just a few sentences of it, perhaps maybe even the whole thing.
Well, as an inspiration.
And said, this is my favorite poem, and you put it in the front of the cover, and you gave the attribution, and we then looked and we're like, you know what, this didn't sell because you put the front, the dust jacket has your favorite poem in the world in it. Then the law would say, okay, this is probably not copyright infringement, it's fair use of that poem, and it's not what drove the sale, it's not infringing it in that sense. And so you have to take it, element by element, case by case.
A lot of times, I mean, I think, and we've had here what writers run into, a song title. How much of a song can you put in your story? Can you use the song title? That becomes where it becomes a question about what's the copyright issue there.
Yeah, so the song titles in themselves generally totally fine, are not copyrightable in any way, shape, or form, barring somebody ripping off. I mean, like there might be a unique fact pattern where you had an expectation that you had written the title and they got it from you, but in general, you like, somebody else, you like the song title that you just heard on the radio and you got it, and that's gonna be the new chapter for my book, take it, right? Like, you're not taking it, that's inspiration of human beings all around, right? As far as the specific lyrics of the song, it kind of comes back to that example, right? Of like, maybe for example, maybe the detective, right, is walking through and he hears this song playing, and you put down the words to the song that he heard, and it fills up the whole page in center column, and that expresses in the story. It's possible in that case where you have repurposed the entire song from somebody, right, and you've given the reader all the lyrics and done there. I wouldn't say they win, but if you got the cease and desist letter from from BMI Music or whatever it is, I wouldn't scoff at it and just throw it in the trash can, right? Especially if your book is selling. But that's the kind of thing that if agents and publishers, right, that's their job, is to go through this stuff, and you'd be surprised that they look through it, right, and they're like, do you really need all the words, the blue suede shoes, or could you just say you walked into the bar and heard blue suede shoes playing, and we moved on to the next paragraph? What do we, and that's also where you get to potentially transformative works of somebody's are not derivative, they're truly transformational. So, and then if you're doing critique, right, if you're like, the dumbest song I ever heard was this, and here's what it was, and you wrote it down, then you can be okay. So that it's messy, right? If you want to avoid mess, the best thing to do is only make it come out from between your ears, right? Don't make it come out from your buddy's ears, don't make it come out from your kids' ears, because people have been sued by their kids, right? Like, just make it come out of between your ears and put it on the page, and you won't have a problem. And then think to yourself, what can I evoke from the reader where I don't have to grab the full excerpt? But don't be afraid of it either, in that there's a lot of fair use allowed under the law. There's a lot of things that I can't tell you to commit infringement on your behalf, but like, there's a lot of things where honestly, if you're not making a ton of money on something, the chance of somebody coming after you is really small. So and then there is a general, it's not a true like leaning in the law towards artists, but the idea that you're making new art and it really is new, right, is different than somebody just repurposing stuff. But think about it. The other thing is, if it sells, you might have the money to ton it, right? Like, there's plenty of artists right now that are just sampling things left and right, wait until they get sued, and as soon as they do, they're like, look, we made enough money with Spotify, here's the payment out, right? And they're on to the next song because they're making money off their fame and publicity. And that's where I get to, what is right for you as the creator? Think through that a little bit, and you will probably come to an answer that is fine for you, as opposed to just kind of looking for bright line rules of how much of a song can I take, how much can I not. Now, there's some things like YouTube will tell you, this certain amount of sampling, we're probably not going to take your stuff down. This amount we are. I think it's in the like 15-second range for them, but even that's just them deciding what is worth their time for taking things down and risking litigation. Yep.
What about public documents, like a newspaper article or a magazine article, and you put it in your book in full? Would that be infringement?
So it could be. There's generally, for historical documents, and depending on how old they are, right? I mean, things do fall into the public domain, and newspaper articles, an example. There's also newspaper articles themselves are publications of facts a lot of times, so it could depend on how the article is written. But in general, you run anytime you're taking stuff from somebody else's creation, right? Which is even somebody writing an article, even an author writing an article here on Hilton Head for the Island Packet is putting in some creativity into it. May not be a lot, and there may not be a lot of economic harm caused by you repurposing their article in that way, but it is possible. Now, if you're doing factual descriptions of things, right, and you're not using it for its economic benefit, and you're just saying, hey, here's an article, we've clearly all seen citations of things in books, and that, the newspaper is not gonna come after you for that, right, either, but there's sort of this question of like, is an infringement, because this is how a fair use defense goes. A fair use defense is not, I didn't infringe your copyright. A fair use defense is, I infringed your copyright, but I'm allowed to, right? And so so there's a lot of things where you ask, is it infringement? And it might be infringement, but is it the infringement that's okay? It might be infringement that's okay, right? And you have to kind of think through those things. My advice to you would be, do the creative process first, come up with what you want, especially if you're creative, and you will come to find out whether that whole article is needed or not, or where does it interplay.
So I keep hearing the difference between really infringement and enforcement. And I think as a writer, especially a writer like very small poems, not big books or bigger ideas, if there's a line in a poem and the line has, we always talk about, like poets always talk about, like, like an original thought, and there's there's an original way it's musically, put into a line, or maybe 2 lines, right, in the middle of a 20-line poem or something like that. It sounds like if 2 lines from that poem, which are really unique, are taken and put in some other poem, right, that would probably not be considered copyright infringement. That's kind of what I'm wondering.
It might
That,
not.
that makes me want to maybe kind of be a little bit more protective of what I share, right, based on that.
So it,
Definitely.
it'd be protective of what you share in a sense, right? It could be, that would be messy, right? 2 lines, like, just use the raw math, I think you said. 2 lines out of a 20-line poem, and then those 2 lines appear exactly verbatim in somebody else's 20-line poem. And maybe I'll throw in and they actually, turns out they were the, 5th stanza, so they closed out their poem as well, just like they did in yours, right? So it wasn't even, they put theirs middle and yours was at the bottom, right? So the last 2 lines of these 2 20-line poems match, and he read, the other person read your poem, saw those 2 lines. That is where it would get messy, right? And this is why it would get messy, because some of it copyright infringement does require access. So we would have to prove that that person saw your version, right? And so if they were living in California and you only published, entered a poetry contest or, did a poetry reading here, and you hadn't published electronically, and there wasn't the kind of, that might just be, would be impossible to prove that they had been here at tonight's meeting or something and saw it. In the world where there's digital representations of things, that could potentially get a little easier, but that's still gonna be like, you've just come up with like the messiest litigation. Everybody better have made enough money to pay all the lawyers there, because no one's walking out happy, and that is the worst case fact pattern, right? What's more likely to happen, and this could happen in today's age, is like somebody sees your poem, likes the last 2 lines because they move them just the way that last stanza was designed to move them, and then they put it on a water bottle, where they go put it, they use it as the opening to their, YouTube shorts and things like that. And then you're going to have really an opportunity to attempt contracting with that person, of reaching out to them through your attorney, saying, having that person decide, hey, is this actually copyright actionable? And again, let's set the stage here. I haven't read anybody's poems in here, so this is hypothetical stanza 2 or 5, right? 2 lines in stanza 5 of a 20-line poem. It does not exist, that we're just talking about hypothetically, and the infringement hasn't happened. And so it's a case-by-case basis, but it's possible, right? In that scenario that they took it, they lifted it, it was the driving factor, right? Because that's some of the things that get weighed, is how important to the work was the piece that was lifted, that they do anything with it, where they, if they, same thing, YouTube short, and they're like, dumbest poem I've ever seen, and this is not how writers should approach, it's absolutely criticism of what you've written,
Right.
that's allowed, right? And so, these are the kind of messy fact patterns, which I think are important to all of you, which is why the questions are flying fast, right? Because it's your work and I'm glad to answer them as best I can. But it also is very much depends, and it depends on what's going on, right? And even in that case, you'll end up having, you know, you get your most teeth for your copyright after you register it. So there'd be a whole process, right, of needing, ideally you'd take that, you'd register the poem, then you'd send them the cease and desist, and then you'd see where it went. All right, I know I'm running up against the time, and we've got a bunch of good questions, so I don't mind, but I also don't want to steal your meeting from everybody. So kind of key details, we've hit at some of these. You need the expression in some tangible form. You'll see that if you ever drop one of the copyrights, e-copyright office, the electronic copyright office system, ECHO, which is how you file things electronically online. You're gonna have to tell it as you walk through the steps of filing how your copyright came into being in what tangible form, and you have to pick that, and then that will guide the different screens. So it's not kind of driving home. You could have an idea, you could have recorded in a bunch of different ways, right? Made a quick cartoon of it, you could have recorded a video, you could have sang a song about your book and written a book. You'd have to register all those individually, right? And so it really does come down to how the expression's thing. Questions for you all that I think are key to take away. How long does a copyright run, right? Copyrights are designed to give the way that they operate right now in the United States, they are designed as a regime to give the author and their estate a chance to benefit from the author's work. So for works of authorship where you were the original author, it's your life plus 70. There's a few categories where that time goes down, and those are anonymous works, pseudonymous works, and works for hire, which is when I ask someone else to help write the book with me or do things. Those are shorter. They're 95 years from publication or 120 years from creation, whichever is shorter. And so some of these, I would say, we just don't have enough time, and I'm glad to come back and talk more about contracts, but when you're reading your contracts, that's one to look at. If you are contracting with someone to have you to buy your book rights, especially up front where you haven't written a book, look for those magic words. If it says in there, this is a work for hire, they're not trying to trick you maybe, but maybe they think they're hiring you to write a book and you think you're writing your creative book, right? Those little words in that contract will drop you into different lengths of that copyright. They will impact your estate and its ability. They'll impact the ownership of it right from the jump when the thing's created. And the last thing, which is not on this slide but is later in there, they will also impact your right to reclaim the copyright. Okay, and so you can't do it for works for hire. There's no chance for there's no chance to reclaim the copyright after a period of time. I think it's 35 or 40 years depending on how it is. So you want to be, that is one I will say. I don't think people are nefarious all the time, but look out for work for hire, right? Burn that on your brain. If you're signing a contract about writing something, look for work for hire. That's fine if you're expecting them to have there be a work for hire, that they're hiring you. But if you're not, if you think you're creating it and they're putting work for hire language in there, you might want to put a big not a work for hire on that, right? Or have a discussion with whoever you're contracting with, okay? Because those kind of magic words can impact your rights.
Sorry, Tim?
Yeah.
You just ran by something prior to that. You know, if I put a piece of work out there, my own memoir or story, that's just a book, but then I did not yet do something with the other videos I might have created around it, or Audible or something else.
Hmm?
Can someone else copy it and then they'd say that's mine, that's not yours, you haven't put it out there?
No, it's your reduction of your creation of the first book entitles you to make and control how the derivative works are made from it. So like the spoken word version of it for Audible, the movie rights about it, those all vest to you as the
Even if I
original
haven't
author.
done anything?
Even if you haven't done it, right? That's part of the copyright, is your right to control how that is.
It assumes I'm copyrighting this. If I don't copyright it,
You have, so maybe that's the thing, it's just maybe the second you created it, you copyrighted it,
I see.
right? You didn't register it yet. Registration has nothing to do with the rights. Registration gives you the ability to sue somebody, right? So in that scenario where they stole it, you'd have to go register it and then sue them in federal court. It gives you a cleaner way, if you have registered something and you've already written it, right, and in your contracts, it gives you a cleaner way to talk about what you're doing.
But they can't register it if I haven't registered it.
No, yeah, so they would have a proceeding where they could try to register something and lie, right, saying that they wrote it, and you would show that you had created it first and that they'd stole it from you. Those get super messy and are not worth talking about tonight, but like, yes, that's them just stealing your work, right? And then, so we already saw this on the,
Let me ask you, how do you prove when you wrote that?
so there's a few ways, right? So the modern word processing sense, you got the date on the things you wrote, and you probably have to go to massive lengths to make that Microsoft Word document fake the date that it was actually transacted on. As other writers, it's very common, right, to know what was the period of time, like if you know that you wrote the book over, maybe you don't have the date perfectly, but you know, okay, in the summer of 2024, I was in Hilton Head, this is when I did it, I sent it to my publisher on this date, or I went to do it, right? So that's how you do it. As far as those really nitty gritty ones, you can't have copyright infringement unless the person has access, right? So if you pull, a Bronte sister, if I'm getting it right, and just leave it in the top drawer, and they write the exact same book on their own without ever seeing your stuff in the top drawer, that's just two people that had the same exact expression of something without ever having access to it, and the other person could register, right? There has to involve some access to have been theft. Now, a lot of times people always claim, oh, I didn't take it, I wasn't there, I didn't do it, right? So we assume access by your publication, but that's what has to be. As far as proving it, if you write, longhand, I would put a date in your notebook every once in a while, right? And that's, that is what's gonna start to prove it. If you, have notes of things and you publish them somewhere, the date that you published it, that's the kind of proof that you get into. There's no magic to it, but that is it.
I just wanted, in reference to that, because, I keep hearing enforcement and really the ability to prove the access, right?
Mhm.
So like a content management system, if I'm registering or submitting my poems through Submittable,
Yep.
right, which has a content management system, they file it, it's in a database, and then I submit it to 20 different people,
Yep.
right? The issue then becomes like in a suit, right? The issue then becomes, I can then go into the content management system and prove,
Yeah, beyond a shadow of a doubt that it
right,
is
that it's in
submitted.
this content management system, you have taken what's in the content management system and you've produced it somewhere else,
Yep.
right? So this is provable, and then the enforcement card, is it worth it? Like, if they only made $2 from it, a lawyer's not even gonna wanna talk to me, right?
I'll talk to you because I'll talk to you, but I won't want to. There'll be nothing to engage about, right?
The only question I have on that though, in the world we live in now with social media, if that happened, that can continue to be distributed. It's not like it's a one-off anymore.
Nope.
Right.
Because if somebody gets a hold of it, they pass it on to someone else, and they pass it on to someone. I mean, is there law starting to address that?
Yeah, so there's a few things, right? So we'll skip ahead. So actually, where did I? Oh, well, it was the next thing. So the DMCA, right, is the Digital Millennium Copyright Act, and that gives you the ability to have a takedown from an internet service provider, even without having registered your copyright. So all you have to, anyone who is an internet service provider or Google, Amazon, those kind of things, they have to give you a medium by which you can declare to them, this is infringing material, I believe this is infringing material, I own the copyright, you need to take it down. There's a process back where the people can say that's not correct and you can deal with it, but that you don't even have to have registered. If that happened where you sent it off to somebody and then it got, let's say some crazy intern, right, took it and put it all over their social media, you should, right, should is always a strong word from an attorney, but in theory, you would go to the places that's at, you ask them to take it down. It sucks, but it does work. I will say, if you think your work is at risk of that, copyrights are pretty cheap, like we're talking $45 for a book, less than $100. If you have something that you think is going to be that level, I wouldn't have you spend a ton of money on it, but if it's something that it means that much to you and you think it might get out in that way, having registered it, the reason I put the DMCA takedown notice war stories is very easy to go to, very easy. Go to YouTube, type it in, tell them what the URL is of the link that you had and do it. They will take it down. The other side, as I've had clients do,
Well,
will
they
pop
won't
up.
always take it down.
They won't always, but in
Amazon won't take it down.
they won't, but when you then come back to them with your actual registered copyright notice, they now know that the damages are running and that you've actually taken the steps to register it. And it's not perfect, but it can help you. Here's my copyright registration as a way to get them to take it more seriously than just the thousands of people that are, you know, mad, two teenagers mad at each other and want the other person's YouTube video down. And so, but it's not perfect, right?
So very quickly, 15 years ago, I printed like 150,000 note cards in China. And what they did is they printed 170,000. I sold my 150. They're still selling them on Amazon, and I've repeated, there's a Chinese company. I've repeated, it says it's published by Herondance, which is my company. And I've repeatedly told Amazon, you know, this is my copyright, and it's still there tonight. You know, that's happened, like over the last 10 years, I've told them maybe 6 times in writing, you know.
Yeah, so I've sued Amazon a few times, right? And so, you know, take Tim Johnson's opinion on the lawsuits he's been in against that interesting company that on its good days is great and on its bad days is really bad. They will respond after you sue them, right? So you need to go get, like, they won't, Amazon specifically, they have a few kind of their normal wiggles, right? So like if you look at the Amazon site and it says, you know, what does it say? Sold by Amazon, right, is the listing, right? And you have other ones that don't, they do as a third party. So they'll do anything they can to say that it's a third party seller the first time you try to do it, even after you've sued them. Then you'll go through discovery, you'll find out that it's not a third party seller, that they're actually stocking themselves because they track exactly what's making money on the site, and they will come back and they will stock it themselves, because if you can drop ship through Amazon, they can drop ship through themselves. And then eventually, if there's enough stuff and a risk of litigation, they may settle with you, or they may see if they can run you out of money. It sucks to go against Amazon. My unfortunate advice in that story is be really wary I know the prices are cheap in China to print stuff. The actual pathway of loss, right, is the Chinese printer did more than they were supposed to and is still making money off releasing them. And that sucks too, right? Give hard advice, which is that few cents you save on printing by having it done in a foreign country might come back and be really painful later. It might not be, right? It may not be the breaker that it's 20,000 over the 150,000, but it sucks. And there's a lot, the e-commerce world makes it both better sometimes and worse, and better in reaching more people and making more sales, worse in getting bit by
When you've sued Amazon, will they stop all business relationships with that client of yours? Like, I sell books through Amazon, I sell my paintings through Amazon. So if I sued them, would they then say, do you know if they would then say, no more, we're not gonna deal with you anymore, we're gonna shut it, everything you sell through us is.
The people I've sued them on behalf of were not retailers through the site, so they didn't have a concern. We never had a concern as original manufacturers of the goods. We were purely chasing the counterfeiters, and Amazon itself is facilitating, making, transacting. We weren't chasing. It didn't matter to us. Yeah, so I have no idea. Right. It didn't matter to us in the least how they think. I will say, they're always changing those terms of service for the Amazon agreements. You do yourself a favor of reading that contract when you go to have an Amazon store, and you go what you're able to sue them for and what sort of redress you have, because it's not just them being the nicest people in the world hosting a store for everybody. Even though you're paying to post your ads, even though you're paying to host your goods and have them do the stuff, read those terms of service. I know I'm running late, so does that, I know it doesn't help you at all in the specific stuff having there, but
it's good.
But yeah, it's a good thing. I'm gonna give you the quick on contracts, right? Contracts are an agreement between two parties to do something, right? And you can pretty much contract, I have a joke and the other thing, if it's not illegal, you can pretty much contract for it, right? And so when we get to your contracts as writers, what are you looking at? The big basics is, what's the work? You wanna define that well. what rights are at play, i.e. are we dealing with the movie rights, are we dealing with the book rights, are we dealing with both, and then what money is involved. And those three things are very common what people end up fighting with later, so you want to think about that as you come into the contract. Once the lawyers have had a chance to look at the contract, you get all these big fancy words, right? Like subsidiaries, termination, publication, reserved rights, sublicenses. But they're really like, when you think about it, the things, if I had to look at a contract and you said, Tim, we got 2 minutes, I gotta decide whether to sign this or not, I would say, that's really dumb, I need more than 2 minutes, let's read the whole thing. But in that hypothetical, we'd look at, what are the rights, what are you giving away, what do you think you're giving away? Okay, and I would ask you, what do you think you're giving away? What are you contracting for? And if you said, I'm contracting for the author's rights, and I saw that there were movie rights in here, I'd say, well, in the 2 minutes, we're not gonna sign this, because it says more than you just told me that was important to you. Royalties, how that's set up, how you're getting paid, how much you're getting paid. Deadlines, i.e. especially if you're doing pre-work for a book that's not written yet, when is it due, right? Because this is where people don't want to pay you because you didn't bring the stuff on time, or they want to claim it wasn't, oh, you put it in the mail, but it was due here in this place on these days. And then termination. And for you, how can you stop working with these people if they turn out to be bums? But also, are there any clauses in there that let them terminate you, right? So you don't want to post something on Facebook and find out the next morning that your book deal's going, right? And so that's what I would do. And how do you get at that? You don't need a lawyer to do this. Read your contract, think about what you want, read your contract again in light of what you want, and then negotiate. I know it's hard, right? Especially as you're writing, you're not, at the pinnacle of your, career, or maybe some of you are in the writing, but not everybody's got the clout of Stephen King, right? And so but you always have a chance to negotiate. You are the ones who created something. You're never gonna get something you don't ask for, right? And it bears on you to sometimes ask for it or to say, I don't think this, and if it is super important to you, go find someone to help you. And so that's those things on the thing. And then the other issues, I just wanna mention them, we haven't even touched on them. We touched a little bit on the idea that it's designed for your estates, right? So if you have works of authorship that have ongoing royalties, you do yourself a favor of getting an estate attorney, telling your estate attorney that you've written materials and that you have authored books. Your agents, if you want to work with a literary agent, there's a whole host of relationships between the literary agent and you. Taxes, if you have royalties coming, books written and things, I don't want to dissuade anybody from doing it, but as you have more success in your writing and there's if revenue equals success for you, you got these questions you might want to talk to somebody about, and then we have kicked all around enforcement tonight. And so that's it from my side. Let's keep answering questions.
Just a quick question. I do have a will, but the fact that I'm an author and have things and I have manuscripts that are sitting.
Yeah.
I mean, if I died tomorrow, they'd be sitting there. Is that covered in my will?
So technically it is, in that it is a piece of property that you have sitting in the house. I would, if how they're acted on as manuscripts means something to you, I would advise you to update the will or write a separate addendum to it and then talk to your trust and estates attorney about having that enforced at whatever state the will is executed in, and that's where it starts to get messy, because intellectual property, copyright's a federal law, that's the same everywhere. Wills are 50, okay. So South Carolina, I'm not a wills, I don't do it day to day, but I am barred in South Carolina. So in South Carolina, it's one of the easier states to execute a will as long as the attorney's not getting anything from it. But so I would update it to reflect those manuscripts and what you want done with them. And then you potentially, to make it clear, if you've sold them or think that they might sell, that you have basically a power of attorney for the estate that makes it clear that they can take action on behalf of the manuscript to do the manuscripts, and call that out specifically.
So my executor wouldn't be enough?
So the executor might be enough, but it starts to get messy on especially if you've have you ever contracted for other rights around the manuscripts or anything? You have to, basically, you are the author right now, right? The estate is not going to become the author, right? The estate is representing the rights that switched over from after you were, death, God rest everybody's soul in this, we're talking about all of our you know, demise at some point, what happens. If you're really worried about it, you set yourself up for the best success, and this is where I don't do this day to day, but my understanding is you will be better. What you want to happen with those manuscripts and exactly ensuring that the estate has all the signatory power that it needs, you would benefit from asking that trust and estate's attorney about it, and then potentially getting them to deal with that specifically, so that all those rights can be dealt with clearly with the estate, instead of wondering, does the estate have the ability to transact that on my behalf?
Just a quick one on AI, or just?
Oh, yeah. Do you all mind? I know I'm stealing your meeting I'll do 2 minutes.
A little bit of the last question.
Okay, so on AI, you know, artificial intelligence, the way most people are talking about it and using today, it's become a super hot topic. There's a bunch of stuff going on there. What applies most to authors is the AI tools as we deal with them now generally are taking a set of data, whether it's a large language model or some other type of distributed network and neural network, however they're approaching the science of finding the data, they need a pool repository of information, and then they need a bunch of decisions and training of that algorithm based on that pool of data. And so for authors, the question is, where did they get that pool of data and what are they doing with it, right? And so for you all, just like we've talked about control of the right to make derivative works, the control of the release of your work of authorship, if they've put your work of authorship into a pool of data and they're doing things with it, whether they're giving it in response to questions or whether they're training models on it, they're doing something with your work that you aren't getting paid for, that you didn't necessarily tell them that they could do, most likely. And so there's questions going as to, is that allowable? And so there's the doctrine of fair use, and this is where authors and software folks, they both use the word copyright, but they come at it from very different sides, right? So when I'm helping folks with copywriting software, it all has some functional purpose to it, right? Which is to make the machine do things. And so there's a lot of fair use in software, because the act of making a machine do something is not a creative act by itself, right? Authorship, almost all of it's creative, right? I mean, maybe there's edge cases of, can I reprint a newspaper article? But in general, the entire novel is novel, right? And so the software folks are like, well, copyright, I can do all kinds of things with it because I'm just using it as a tool. And the authors are saying, well, no, you're taking my creative work and you're giving other people creative expression from that, especially when we're talking about some uses of ChatGPT. And those worlds are colliding right now in the courts because it's not clear from a legislative side. If they don't settle, if you keep the eye on the class action lawsuits that are growing right now, if they go all the way to the mat, you'll get an answer from the courts in a few years as to whether that's allowed or not. If they settle because the people that have been accused decide it's worth it to them to pay whatever they have to and get to go out, it won't be settled. There is not some massive legislation rolling through the American, Congress right now to come save us all from what to do with data lakes and who's allowed to have them. I will say, look at anything you're doing, read all your use cases. So even that, even if you're doing a content management system, right? Read your agreement, see what it says they can do with your data. And if you don't like what they can do with your data, sometimes you can actually call them and negotiate it, and otherwise you can not use that service, right? And that's very quickly on AI. I will say it shouldn't be that scary. There's been, in my short time, there's been cryptocurrency, there's been, processing speed will come for all of us, and now there's AI. It probably is not as bad as some people want us to think on each day, but you own your stuff. Try to read the agreements, try to protect it that way.
Thank you, Tim.
All right, you're welcome.
Appreciate it.